Good afternoon, everyone. Thank you very much for joining today. Welcome to this How's Percival webinar on the ESG agenda and some tools and tips available to business leaders and in-house lawyers when considering what's next on the ESG roadmap. Thanks very much for joining us. You'll see we are recording the session. We will send the recording and the slides to you. We have an hour for the session. And there will be time for questions at the end, so please put any questions in the Q&A at the bottom of the screen. If you've got any technical issues, then please do put them in the chat and our technical team will work with you to resolve them. I'm Paula Dunbill, partner in the commercial team. I specialise in technology contracts and work with businesses on arrangements such as outsourcing, supply contracts and service delivery. Miles Barnes joins me this afternoon, who's a senior associate in our commercial team. Miles advises on a range of commercial and contract trading arrangements, but he's also a corporate lawyer and he looks at business sales and restructuring. And Miles is one of our key members of the food and beverage team. We're also joined by Rob. Rob Starr's a partner in our regulatory team who advises companies and individuals. He's really experienced at representing clients under investigation by enforcing authorities. He's a former prosecutor with the SFO and he frequently advises on issues such as health and safety, directors' duties and crisis management. So I'll start by looking at the agenda for today. First of all, I'll set the scene really in looking at what we mean by the ESG agenda. So you will be aware of all of the different issues there are and the drivers behind it. Miles would then look and move on to one of the more standard-based approaches to ESG in the form of B Corporation certification. So he's going to look at what B Corporation certification is, what needs to be in place and the pros and cons of it. Rob will then move to an update on anti-bribery, looking at some of the key elements of the offences, the defences and penalties, etc. And then I want to bring it back to a close by looking at some of the more practical approaches to identifying ESG risks and some of the tools available out there to mitigate those risks in contracts. So what are the drivers behind the ESG agenda? So first of all, what is ESG? Well, it's in the title. It stands for environmental, social and governance. So it's really about the way that companies and investors are thinking about issues like the environment, climate change and sustainability, workplace safety, diversity and inclusion. It thinks about how it thinks about its relationships with employees, with suppliers and with customers, and issues like its executive pay, its leadership, its audits, its internal controls and its governance. And if we think about what the drivers are, we've got on the global stage currently, we've got COP27 that's in Egypt till the 18th of November, where climate change is front and centre of all the news headlines. The UN Secretary General has said that humanity is on a highway to hell and we've got to change course now or face collective suicide. The delegation heard from Pakistan's Prime Minister, who talked about the catastrophic floods that 33 million people had experienced. They'd had 7 times the average of extreme rain and it washed away more than 4 million acres of land. And then we've got severe drought in Africa, which left more than 150 million people threatened by extreme hunger. So we've got these world-changing events happening. Where are the pressures coming? So that what are the governments doing? So the governments are shaping national net zero strategies. In 2019, the UK set itself a target of carbon neutral, a net zero carbon target for 2050 under the Climate Change Act. And governments are using policy levers like incentives for low carbon technology, tax incentives to encourage emission reduction, and then increasing adoption of voluntary standards, but also legislative requirements coming down the road in terms of ESG items. We've got society, that there's pressures, so there's evolving expectations on what we expect from our corporations, millennials wanting to do business with companies that align with their values, and we've got pressure about reputational risks in a supply chain where there's unsustainable practices. One of the big drivers is stakeholders. So stakeholders in the form of investors, consumers, and the workforce. Stakeholders are applying pressure, investors are saying they need to see targets, consumers are choosing brands for their ethical behaviours. 1 in 3 businesses of the largest listed companies in G20 have net zero targets. That's up from 1 in 5. So businesses are responding to these pressures and showing an increasing commitment to the ESG agenda. They're looking at their tax strategies and their investment outlooks. And then for the in-house lawyers amongst us, we've also been led by the SRA, who in December 2021, their policy statement said they placed the utmost importance on ensuring a core focus on the environment. And the Law Society as well, it's recognised the importance of initiatives like the Chancery Lane project that I'll talk about a bit more later on, where we've seen increased awareness of climate change clauses. We've got new legal practices that are dedicated to ESG matters, interestingly, so greater specialisation, and we've got lawyers themselves specialising in biodiversity and climate risk, for example. So it's a hugely broad agenda. There are many drivers behind it. It covers a vast array of issues. One of the approaches from governments and from businesses is to be looking at the development of reporting standards, which aim to provide an objectivity when assessing a business against ESG criteria. One of those business models that's growing traction in the UK is the B Corporation certification. So on that note, I'll hand over to Miles, who'll tell us more about it.
Thanks, Paula. Yes, so for the purposes of this session today, I'm assuming that no one on the call has ever heard of a B Corp or knows what it is. I appreciate that's probably not true. So if anybody has got some experience or has looked at this before, it'd be great to hear at the end, and apologies if I am teaching anyone to suck eggs a little bit, but I think it's a useful overview. Because as Paul has just touched on, sort of ESG as a topic is a fairly nebulous one and actually covers such a wide range of potential topics and issues. It can be quite hard to know how to start and actually how to get a handle on it within your business without it becoming quite disparate and separate and trying to do various different things at the same time. And the B Corp certification is quite a good way of doing that. So what is a B Corp certification? Well, it's effectively designed to be the gold standard for ESG compliance within business. It's been established by a nonprofit called B Labs and is designed to set out specific standards and criteria and processes that businesses should follow if they want to be deemed a responsible employer and a responsible business, not only in terms of generating profit and returns for their shareholders, but also in terms of their impact on the wider society. I've given some examples of some current B Corps here. It is an internationally recognised standard, so it's not just UK based. It's particularly popular in the US, but there are B Corps all across Europe, as that shows. And in theory, I say in theory, I'll come on to this later, it's an objective set of standards to show that you are meeting best practice in terms of ESG. Not necessarily the case, but I think it's definitely a good starting point if you don't know where to begin. So what are the benefits of being a B Corp? Well, there are a few. As I've sort of touched on, what the B Corp certification does is it provides a holistic system that you can use to establish better standards across your organization. It covers issues like environmental compliance, supply chain compliance and best practice, and also areas like HR, trying to make sure that all of your stakeholders are being treated fairly and in line with modern expectations. And as a result, it's a clear way to improve standards across the organization in a way that's measured and is consistent and has been tried and tested, as opposed to you having to develop your own policies and procedures internally, which may or may not be at best practice. Along with that, as I say, in theory, it's objective because it's been set by a third-party non-profit. I do have some question marks on that because it is still being set by somebody. So there's only so much objectivity, and different people across the ESG issues will prioritize different things. But what it does mean is that because somebody else is setting those criteria, not only are they best practice now, they also evolve over time. So they provide a clear way for your business to make sure that you're staying up to date with what's best practice as that changes over time, which, as we've all seen the last couple of years, ESG is a real moving feast, and what's expected of businesses is changing at quite a rapid rate. The last key benefit really is the PR that you can get off the back of becoming a B Corp. Obviously, that's not the only reason to do it, but it is something that is becoming more and more recognised, both in the business community, but also with consumers. And you'll see a disproportionate number of those businesses on my last slide are consumer-related businesses, because it provides a clear recognition that this is a responsible business that's taking action, again, not only to generate profit, but also to try and contribute to society. There are some downsides of being a B Corp, though. The first one is it's not an easy process. Anyone who's been through other certifications before, particularly ISO certifications, knows it's quite a laborious and time-consuming process, particularly the first time you do it. There are a lot of different standards that you need to try and meet to become a B Corp. Some will be things you're already doing, others may not be, and may require a lot of buy-in across the organisation and a lot of changes in order to get there. It's also a very slow application process, and people have talked about it taking a year, 18 months, 2 years in some cases before they've got certification. The management of it doesn't end on certification either. It's an ongoing renewal process, much like ISO and other certifications, where you have to continually show compliance, you have to report on an annual basis, and as those standards move, like I said before, you need to move with them in order to stay compliant. So there is a degree of ongoing maintenance and management there that you need to be ready for before you decide to apply. There are also some practical downsides to it. One is that it's probably not a great fit for every sector. In theory, B Labs advertise that B Corps are great for everyone, but in reality, a disproportionate number are consumer-focused businesses, and particularly in areas like food and drink, which historically have had well-advertised supply chain problems, and therefore have been more keen to address them in this way. I suspect, depending on the sector you're in, it would be worth doing an assessment to see actually whether it's a good fit or whether some of the requirements just on for example, the openness you have to show in terms of your HR policies, which just wouldn't be a fit for everyone. Sorry, I understand I've frozen. Can you hear me now? Sorry about that. It's a good time for some dodgy internet connection. Right. Come under some criticism recently, particularly with Nespresso recently being awarded B Corp status, which received a lot of backlash because of problems and human rights issues within their wider supply chain. That's just one case study, but I think there has been some general criticism that perhaps there are loopholes in the B Corp application process that mean it may or may not be the gold standard it claims to be. The process, if you wanted to go down the B Corp certification route, as I mentioned, it is quite extensive, but it's easy enough to get started. So the first step is an initial assessment, which you can do on the B Labs website, and that will ask you various questions about what your organization does and doesn't do currently, and then it will give you a point score. Now, you need to get at least 80 points on that assessment in order to proceed with an application. But what it also does is highlight areas where perhaps you're not at best practice at the moment, so that you can go away and address them, either because you want to pursue the B Corp certification route, but also actually just if you want to see how you're matching up to best practice even if you don't want to go down the rest of the route. So I would recommend actually anyone has a go at that assessment. It's quite useful to get an independent sort of verification of where you are. If, having done that assessment and taken any internal steps you need to do to get up to the required standards, you decide to go ahead, first thing you've got to do obviously is get internal buy-in, and I would argue that probably needs to be at board level, given that this is an all-encompassing compliance requirement that will affect the whole business. You then submit a full application, which goes through a couple of stages of evaluation and verification, which will involve B Labs looking at the answers you've given on the initial application, requiring you to complete what's called a disclosure questionnaire, and also asking you for evidence to back up what you've said you're doing to prove that you are. Again, that evaluation and verification can take some time. It can be 6 to 12 months end to end, and I suspect that's probably going to get longer as this becomes more and more popular. If you get through all of those hurdles, then the last stage is effectively you have to sign up to a couple of documents. One is the B Corp agreement, agreeing to comply with the standards that apply to all B Corps. And another is called a declaration of interdependence, which sounds suspiciously like a clever marketing gag to me rather than anything substantial. But it is a requirement, effectively trying to show you're thinking about others and not just yourself. You then have to pay a fee, and then you get certified. Now, this wouldn't be a lawyer's call if I didn't talk about some of the legal work that's involved if you want to be a B Corp, because there are some specific requirements and then some more general ones that may require a bit of work internally if you decide to go down this route. The first and probably most significant is that to be a B Corp, you have to change your company's articles of association. B Corps are required to introduce effectively an additional director's duty, which goes above and beyond what the Companies Act requires directors to do. Now, that duty is to consider wider stakeholders, the environment, social issues, and governance best practice in all decisions that the company makes. Now, it's fairly easy to put that into a set of articles of association, if I'm honest, but actually having that as a standard across every decision you make in your business can be very onerous. And once it's in your articles of association, you have to comply with it. Otherwise, there's various different means of redress, particularly for shareholders or investors that are unhappy with any non-compliance. If you do that as well, as I'm sure many of you know, you'd need to get shareholder approval for that change of the articles, which, depending how your organization looks, may be quite straightforward, or it may be quite a big piece of work in itself. A few other more practical things you may need to look at when it comes to becoming a B Corp. One is whether you need a supplier code of conduct or whether you need to update one you've already got to align with the standards. Another is looking at standard contract templates to see how you can introduce more compliance and more measures to manage the standards, which Paula will touch on a bit more later on. And then other things like the employee handbook and policies you've got. B Corp have quite a lot of standards around HR and how you treat your employees, so that they will need looking at. And then other templates like your board minutes, your annual reports, which will need a section for the B Corp reporting, and also risk assessments, particularly around your supply chain. So that is really everything on becoming a B Corp. As I say, it's not for everyone, but it's definitely increasing in popularity and can be a really useful way to sort of manage ESG compliance across the organization in one go. So from a very general look at how to do ESG compliance, I'm now going to pass you over to Rob, who's going to focus specifically on bribery and corporate liability.
Thank you, Miles, and good afternoon, everyone. As everybody's alluded to, I'm going to have a look at some aspects of the Bribery Act, but this is not a Bribery Act session, so I'm not going to do a full training element. I think what I would like to focus on is really the G from the ESG and highlight how good governance is essential in organisations protecting themselves against criminal liability. The Bribery Act provides a good template for this, But moving forward, there are lots of proposals which will be which are under scrutiny, which may come in. That means that sort of good governance is going to be more and more important in the future. So the Act itself created three principal bribery offences. The first of bribing another person, which we refer to as active bribery. On the flip side of that, we then have an offence of being bribed, which is under Section 2 of the Act, and that's often referred to as passive bribery. Now, whilst this does apply to corporates and other organisations, it does generally tend to be individuals who are involved in the receipt of bribes. In addition, there's also a specific offence of bribery of a foreign public official, the FPO, which again is another example of an active bribery offence. So the giving of or the offering of a bribe. Now, these three offences can be committed by individuals, but they can also be committed by commercial organisations, corporates, non-incorporated bodies as well. In order to prosecute a corporate under these offences, that any prosecuting agency would have to rely on what's known as the identification principle. So essentially, it would have to look at the actions of certain individuals, those that are considered to be the guiding mind and will of the company, and look at their behaviours. And if they have committed offences under the Bribery Act that are deemed to be offences for and on behalf of the organisation, then that commercial organisation can also be prosecuted. Now, the identification principle is a difficult one for prosecutors to manage, and the upshot is that it's often difficult to hold corporate offenders to account through this. That's one of the reasons why the Bribery Act introduced a unique failure to prevent offence. So under this, the onus is very much on the commercial organisation to ensure that they have procedures in place to try and prevent either their employees or others that are working for them from committing bribery. So as it is sort of fairly clear on there, it's a failing to prevent bribery offence. It can only be committed by a relevant commercial organisation, so an incorporated body or a partnership. And the offence is committed where that organisation fails to prevent bribery by an associated person. Now, by bribery, I mean active bribery, so under Section 1 or Section 6 of the Act. And it is intended that that bribe is there to essentially convey a business benefit to that commercial organisation. So who's an associated person? Well, that's anybody performing services for or on behalf of the organisation, and that tends to be a matter of fact. So the actual circumstances behind that bribe would be looked at. But generally, an employee will be an associated person, but also any intermediaries, consultants, subcontractors, and in some cases, sort of suppliers can also be as well. Now, the offence is a strict liability offence. So all the prosecutor would have to show is that a level of active bribery has occurred. It doesn't even have to be prosecuted necessarily. But if a prosecutor can evidence the fact that active bribery has occurred, then the burden of proof falls to that commercial organisation to demonstrate that it had adequate procedures in place to prevent it. Now, what are adequate procedures? Well, that's the big question, and that's where governance falls in. So the Ministry of Justice has produced some guidance, and that guidance sets out 6 principles of what those adequate procedures are. And this is really where the governance piece kicks in. So the expectation is that the commercial organisation will have its own proportionate procedures. Now, what does that entail? Well, that will include as a minimum an anti-bribery and corruption policy, an ABC policy, and there would be an expectation that the organisation will have anybody who is acting as an associated person, anybody performing services on their behalf, will be signed up to its policy and signed up to its procedures, and that there are controls in place to manage that associated person. Paul is going to talk about contract controls in a bit, but essentially that there are measures in place to try and control and manage the behavior of those performing services for you, but will also have the consequences for failing to comply with your organization's expectations spelt out in a contract with consequences for breach, for example. A particular area of adequate procedures that need some focus is risk assessment. So what is the organization's likely risk from bribery? And that can be from the sector in which it operates, the territories in which it's operating, etc. But in addition, has their associated persons, have their consultants got risk assessments of their own? Have you seen them? What controls are in place in relation to those companies and organizations that are working for you? A massively important area which is often overlooked is the conducting of proper due diligence. So there will be a lot of talk around supply chain and making sure that there is appropriate due diligence in your supply chain, what is coming into your business, for example, but often not enough undertaken about those that are going to perform services for you. So have you taken references? Have you done some kind of publicly available search? Have you looked at the type of areas that they're operating in, what their reputation is really like? These types of exercises are going to become increasingly more important. Essentially, you need to know very clearly who you are getting into bed with. And communication and training, monitoring, review are all equally as important. It's quite funny how many organizations we see that say, well, we've got all of our ABC stuff because we've got a policy. What training have you given your staff? Well, none. They may have read the policy on induction. So it's equally important to make sure all of this is in place, that it's continually monitored, reviewed, and tested. You can't just have a policy that sits idly on a shelf gathering dust. Now, there's not been a great deal of case law in relation to what adequate procedures look like and what they should be. But there has been one contested prosecution under Section 7 of the Bribery Act, and that's Scanson Interiors. So Scanson were a refurbishment company, and they were pitching for a raft of work from a property company called DTZ. And as part of their pitching for work, 2 bribes totaling £10,000 were paid by the managing director to one of the property managers at DTZ. And there was an agreement for a 3rd bribe totaling £29,000 to be paid at a later stage. And for this, Scanson were receiving confidential information relating to the bid and tender process. The bribes were being routed through a separate company that was owned by the managing director's son. And so the belief was that this was all hidden, wouldn't come to light. Later on, a new CEO joined Scanson and was asked to sign off on this £29,000 payment, and clearly felt there was something a bit dodgy about it. And when he looked into it, was concerned about what these payments were for and self-reported. Ultimately, the company were prosecuted. And as part of their defense, they were saying, well, actually, we're a very small company. We've got very few employees. We operate in an open plan office. We don't really have an anti-bribery policy, but we've got a load of other things that are in place that deal with our ethical responsibilities and controls. And this was simply not accepted by the jury. They felt that actually, clearly, the procedures that they had in place were inadequate, and you can't simply rely on the fact that you're small and relatively transparent. As part of that case, the prosecution also made various representations about the types of things that they would expect to see. And unsurprisingly, that included things like having a policy, having appropriate training, perhaps having documented compliance controls, and also maybe appointment of a compliance officer. So indicative of the types of things that need to be drafted, documented, refreshed, and so on. Now, the Act has been in for 11 years, and you will be aware that the penalties introduced by the Act were fairly significant. As an individual, you can go to prison for 10 years, and you can be disqualified from acting as a director for up to 15. And on the corporate side, well, the fines can be huge. You can be debarred from undertaking any public sector contract work. There is civil recovery, but also criminal confiscation relating to the proceeds of crime, and most significantly is the potential for reputational damage. As I mentioned earlier, if you are having to undertake due diligence on whether or not you get into bed with a certain organization, you're going to be very reluctant to engage with one who has a conviction for bribery. Now, these cases take a long time to come to fruition, and the average for prosecution of a fraud case by the Serious Fraud Office used to be about 7 years due to the vast amount of material that has to be obtained. But in the 11 years since the Act came in, there have been a number of cases which have been prosecuted, and also some which are in the throes of investigation. And these are some sort of publicly known examples. So just to give you an idea of the types of penalties that you can face, the Alka Fasteners case was one where the managing director, Carol Hodson, was prosecuted. She had paid £293,000 worth of bribes to the purchasing manager of one of her clients in order to win approximately £12 million worth of contracts. That was paid through a series of 64 cash installments that were then hidden through a series of false invoices. She was prosecuted for one offence under Section 1 of the Bribery Act for offering a bribe, and was imprisoned for 2 years. She was disqualified from acting as a director for 7 years, and she had to pay £5 million in total in confiscation and also prosecution costs. Petrofac are another good example. They pleaded guilty to 7 counts of Section 7, the failure to prevent offence, and that related to £32 million of bribes that were paid over a 6-year period to try and win oil and gas contracts in various places around the world. They had to pay 77 million in total, which was a combination of confiscation of the benefit of those bribes, a 47 million pound fine, and 7 million pounds in costs. And more recently, perhaps just to sort of confirm the old adage that crime doesn't pay, Glencore, who are a very famous operator in the extractives industry, were recently sentenced in relation to bribes paid over a number of years, totaling 29 million to try and access or get preferential access to oil reserves in Africa. They were found guilty of 7 counts of bribery, a mix of Section 1 offences and also the failure to prevent offence. And they were sentenced a couple of weeks ago to the largest ever UK fine, totaling 281 million, or just shy of 281 million pounds, comprising a large fine, confiscation of all of the profit from the contracts awarded through bribery, and then also the Serious Fraud Office costs. So huge consequences if things go wrong, and an indicative, I suppose, of how the failure to prevent bribery offence is now working. Now, moving forward, and since the Bribery Act came in, there has been a continued evolution of how we prosecute corporate offenders and how we hold corporate offenders to account. So that includes, for example, new provisions under the Modern Slavery Act, where the onus is on businesses and organisations to produce, for example, a modern slavery statement that explains how they are managing slavery and human trafficking in their own business and supply chains. And a further example of a failure to prevent offence came in through the Criminal Finances Act in 2017, and that's a failure to prevent tax evasion or facilitation of tax evasion. And again, that is subject to a defence of reasonable prevention procedures, which are essentially identical to those under the Bribery Act, the adequate procedures. Now, moving forward, the way in which companies are going to be held to account is going to continue to change. And there has been a Law Commission review of how corporate crime can be reformed, and to look at the potential for new offences. So one of these was, and has been discussed for many years, a failure to prevent economic crime. The Law Commission feels that that's actually a bit too wide, but it is looking at a number of other options as to how they may strengthen corporate liability for a number of serious offences. So that's looking at whether or not the identification principle is moved around, whether or not corporates can be held to account in a different way. But I think most likely is going to be an extension of the failure to prevent offences. The one that is looking as though it will be brought in sooner rather than later is this in bullet point 3, failure to prevent fraud. And the House of Lords have recently looked at this offence and are of the view that actually, following their review, this is needed more than ever. Estimated £4 billion worth of fraud annually and certainly they are looking at whether or not this should be used for those who are enabling fraud to happen. So banks, payment platforms, online services, and so on. So there's quite a bit of focus, sort of drawing to Paula's expertise in the tech world, quite a lot of focus on the digital space and how people are using that for fraud. So that's the future. We're not quite there yet. So the main thing is to focus on what you have in place right now, which leads nicely on to Paula and contract controls.
Thanks very much, Rob. So Rob's looked at some of these. We referred to 6 principles relating to adequate procedures from the Skansen case, and 3 of them were, he talked about risk assessment, due diligence, and monitoring and review. So in the context of contract mechanisms and contract controls, I want to pick up on some of these mechanisms more generally to see how the legal function in a business can support the ESG agenda. And the support will be by defining areas of ESG risk, understanding the sector through due diligence, using contract controls, and I'll talk about some of them that are available, so contract clauses that there are out there, some KPIs and metrics that might be available to businesses looking to build into the contracts. And we've already alluded or actually expressly referred to the kind of downstream, upstream contract compliance issues that all businesses are facing currently. So defining areas of risk in terms of ESG risks that a business faces, I thought this kind of taxonomy really of ESG issues was actually really very helpful. So an organisation called RepRisk, which is a data science business in Zurich, it specialises in ESG and business conduct risk research, and it uses a combination of AI, machine learning and analytics to look at what businesses are publicly disclosing. The RepRisk flags and monitors any risks and violations of standards, and I think it provides a helpful model of each of the E, the S and the G in terms of what risks there are to businesses operating or looking at their ESG agenda. So just to take an example, if you look at the kind of S, the social, the types of the areas of risk that it's specifically identified are human rights abuses and corporate complicity, impacts on communities, local participation and social discrimination. And then in terms of employee relations, we've got forced labour, child labour, freedom of association and bargaining, employment conditions, occupational health and safety. Just at the bottom, they've got what they call kind of cross-cutting. So there are certain risks that go across the E, the S, and the G agenda. So if a business has controversial products or services and the health and safety, environmental impacts, then that's obviously a key risk, and supply chain issues, and clearly violation of laws and standards. So I thought that was quite a useful model really for thinking about where the areas of risk are in terms of contracting, because in order to look at what our contracts need to do and need to deliver, we really have to have an understanding of where those risks are in our particular businesses. And of course, Rob mentioned that risks vary by territory and by sector. And for example, just to take a couple of extremes, in the mining industry, for example, the key risks that they've identified relate to health and safety, air quality, greenhouse gas emissions, wastewater, hazardous waste. And then on the other side, we've got development banks. Their key areas of risk are impact on communities, human rights abuses, fraud and corruption. So in terms of your contracts, it's important to understand what the sector is, where the risks lie, in order to build from there in terms of what your contracts need to be addressing on a day-to-day basis. So many businesses will voluntarily undertake a degree of supply chain due diligence. Rob's already mentioned in terms of the Bribery Act how important it is to have those due diligence mechanisms in place. some of the supply chain due diligence is mandated. For example, under the Environment Act, you've got a provision to prevent illegal deforestation, where large businesses have to implement a due diligence system in relation to use of forest risk commodities, and they have to report annually. There's the GB illegal timber regulation, where there's a prohibition on operators from placing illegally harvested timbers onto the market, and there's a requirement to follow a mandated due diligence system. And then we've got some more recent February 2022 proposals for corporate sustainability due diligence directive, where there is a proposal for a new duty to be integrated into corporate policies by large companies, so either large companies and/or companies in what they call high impact sectors like agriculture, textiles, or extraction of minerals, in order to identify adverse human rights and environmental impacts in their own operations, but also in the operations of their subsidiaries, their direct and indirect business partners in their value chain. And there is an element of the proposal where there's a requirement for directors of the in-scope companies to integrate due diligence in their corporate strategy. So we're likely to see not only those requirements on the corporates, but also on specific directors. So before entering into any trading arrangements for raw materials, goods, services, it's increasingly important to really understand who you are trading with. Get your specific due diligence on your supply chain sorted, understand the areas of risk, and assess suppliers in terms of their policies, their supply chain management, your suppliers sourcing. Only when we've got that understanding can we really turn to the contract and work out how the contract might help us to facilitate our ESG agenda. So having identified the areas of risk and understood that, the legal team can then look at drafting clauses to help support our ESG agenda. And creating model clauses for use in supplier contracts is a key area, a key step in the process. I mentioned earlier that the Law Society talked about the increasing importance of initiatives such as the Chancery Lane project. And that's a project that has increased awareness of climate change clauses in particular. And I thought it was worth just identifying a specific extract. It's a very short extract. The Chancery Lane project is a collaborative, it's not for profit, it is politically neutral. It's an initiative of legal and industry professionals in a world where they're looking for every contract to enable solutions to climate change. And they've got a bank of 100+ contract clauses where law firms are encouraged to incorporate the clauses into their precedents, and for clients to use them in commercial agreements to facilitate the delivery of climate solutions. The content's all free, it's freely editable, searchable, and it's interesting, it's got an interesting breadth. So they have some what they call low ambition clauses, which kind of reflect a business's start on the process, perhaps a start on the journey to being climate conscious, to clauses that are more what they call high ambition or best in class. Now, the one that on the slide there is Matilda's annex. I've just selected 2 bits where you see it starts with an acknowledgement about a net zero target. So it is just saying this is the context in which we are trading. And then there's a commitment on the supplier to measure and to report and to build that clause into its supply chain contracts. The high ambition clauses will go much further than that, and it will have lots of practical steps to follow net zero goals. So it will have a requirement for a clear action plan to reduce emissions, for example, board oversight and annual reporting. It will address specific emission scopes and look at extending a breach to a termination right or offset payments for failure. So it has specific remedies in it. Just a few days ago, the Law Society posted on LinkedIn encouraging lawyers to use their skills and take action by using the climate clauses in their contracts via the Chancery Lane project. So if you have time, have a look, have a search around for the clauses they use. they are complex, but they give a very good feel for the kinds of clauses you can start from and use and bespoke to your business. So as well as introducing contract clauses to mitigate the risk, we might also look at green KPIs. So as a technology lawyer, I'm obviously used to key performance indicators on service delivery, but actually less so do we come across contracts that look at wider ESG risk areas. I think more so in public sector and framework agreements, we're seeing a lot of that, but in the private sector, I think less so. So with a better understanding of risk areas, it may be possible to come up with some specific metrics that you can speak to your suppliers about compliance with. So if you've got a business that uses a lot of packaging, how can your supplier work with you to create the packaging out of recyclable materials? It's measurable. It's easy to justify in negotiations, and it also looks at that stakeholder piece. So it demonstrates your ESG credentials to directors, to shareholders, and to investors. So the metrics might include, some of the traditional ones we've seen, the carbon footprint, one of the most important KPIs. So the amount of carbon dioxide that's released into the atmosphere as a result of the activities of a business. It tends to analyse a broad range of data from not only from the company in question, but also from its suppliers and customers. So it measures emissions and how you can assess the market presence of a product or service and its impact on climate change. And when we talk about measuring emissions, there are 3 different types of emissions. So there's scope 1 emissions, which are direct emissions from businesses' own controlled sources. So emissions from boilers, on-site energy. The scope 2 emissions, which are indirect emissions from purchased energy generated off-site and consumed. And then there's scope 3, where the supplier is indirectly responsible up and down its value chain from sources it doesn't own or control. So if we're talking about an emissions target, what do we really mean when we're saying, you need to reduce your emissions? Are we talking about scope 1, the ones you're in complete control of, or are you talking about scope 3? Much harder to capture, much harder to measure, but actually a better goal in terms of understanding that carbon footprint. You might have measures around energy consumption. There's lots of digital tools around out there to assess how much energy operations use, to look at whether they can save costs, produce fewer emissions. Supply chain miles is one you'll be very familiar with, the number of miles, the distance that goods are travelled across the supply chain. And measuring that, only when we measure it can we really understand what the solutions are for reducing emissions. You might have KPIs around waste reduction and recycling. I think I saw Decathlon recently had a new initiative where they're encouraging customers to bring back unused goods. They're looking at reuse, they're looking at recycling. Consumers are looking at recyclability of products, and businesses will benefit from monitoring their waste and looking at how their products fit into that kind of circular economy. And then social impact. Businesses have to record the information that how they treat their suppliers and the social impact of their operations. So there are various KPIs that you can build into a contract. You need to think about whether you're capturing just the business, whether you're capturing all subcontractors or suppliers. Do you want them to measure upstream and downstream in terms of that value chain? And then I've also mentioned greenwashing there. So greenwashing is that practice of making exaggerated claims to environmental credentials. There have been the Competition Markets Authority have conducted investigations, and of the cases it reviewed, it found that around 40% of claims made to consumers could properly be labelled as misleading. So labelling a product as having a certain environmental impact or sustainability of products or services, there have been quite a lot of cases of misleading information. So we've talked about contract controls, we've talked about KPIs. If you're acting for the supplier, it's obviously not a one-way road. This is a two-way street. It's about the whole supply chain process. So we've talked about due diligence, we've drafted some bespoke clauses. How might a supplier respond when we're negotiating those contracts? Well, a supplier is going to look at, are the requirements clear and unambiguous? I've already mentioned the emissions, scope 1, 2 or 3. Are we being really clear about what we're expecting them to measure? Are we being realistic about the extent to which they can measure those emissions across its supply chain? Do the obligations need a plan? What do they need to include in a plan? Should we be saying there's a specified format? So for suppliers, they're going to be very keen to ensure that the requirements are clear. They need to know whether they're operationally achievable. How does it relate to their internal targets, their code of conduct, their other policies? Is there a good fit between it, or are they diverging so that the business has to put in a whole new separate process over time in order to generate the information about the KPIs? A supplier might also be saying, actually, are these legal obligations or voluntary? We've talked about the ever-changing landscape. Legal obligations are increasing, but also there's a whole raft of voluntary obligations. So suppliers are going to be saying, actually, I'm okay, I'm comfortable with the legal requirements, I understand the voluntary requirements, but actually it may not align with my roadmap just yet. So suppliers might be looking at coming back to you and saying, it does align with where I want to be, but it may be that we need a plan that comes into place over time. Suppliers will also be looking at baseline against market practice. What market practice is, we're learning more about that each day. Is it, by territory, by sector? How does what we're being asked to do align to market practice? And one of the important things, actually two of the important things, is how are we going to pay for it? So can the supplier meet the obligations out of the existing budget? Does it need additional reporting? Does it need to renegotiate the pricing? How is it going to recover its costs? And then the final point is important in terms of the contract. What are the consequences of the breach? And are they proportionate to the obligation? So, for example, would a breach lead to a termination right? Is that proportionate in relation to the arrangement? Or is there a rectification plan built in, for example? What kind of contract mechanisms do you need to build in order to give that obligation some contractual teeth? So we've rehearsed what the ESG agenda is and the drivers for change. We've looked at the requirements of the B Corp as part of our toolkit. Rob's looked at anti-bribery requirements, and then we've looked at some of the contract mechanisms available to promote the ESG agenda. It's not a one-size-fits-all. It is a whole package of many, many different measures, and it is a changing landscape of regulation and standards. So that concludes our presentation for today. Thank you all for listening. If we can move on to any questions that have been raised since the start of the presentation. So over to you, Miles.
Yeah, so we've had a couple of questions through, but if anybody's got any more just in this last few minutes, feel free to pop them in the chat or the Q&A box, and we will do our best to get through everything. The first question I've got is probably one for you, Rob, just in terms of what directors might be liable for personally when it comes to bribery.
Yes, so I mean, obviously I suppose straightforward thing as individuals, they can commit offences under sections 1, 2 and 6 of the Bribery Act. So both the active and the passive bribery offences that I referred to earlier. So offering a bribe and receiving a bribe and bribing a foreign official. Obviously, they can be prosecuted for those directly. But in addition, in respect of those offences in particular, there are what are known as consent and connivance provisions. So if sort of bribes are paid by guiding minds of the company, for example, such that you can argue that the company has committed a bribery offence, you're also allowed to look to prosecute those directors that perhaps didn't stand up and say anything or seek to challenge that. So if they were aware that these bribes were being paid and simply allowed them to continue or turned a blind eye, for example, that would be consent or connivance, and they can also be prosecuted at the same time as the company. So that's a provision under section 14. The only caveat to that is that they have to have sufficient connection with the UK for it to be done here, because obviously a lot of the bribes involved are out of our jurisdiction. So that would mean that they're either the offence was actually undertaken in the UK, or that they have a specific close connection. So perhaps they're a British citizen or they're ordinarily resident here. So that's the only caveat. I've heard it said a number of times that you can consent and connive to the failure to prevent offence, but that's not the case. You can't. It's a very specific and only applies to corporate or commercial organisation. So you can't be individually liable as a director for consenting or conniving to that failure to prevent offence. Oh, has Miles disappeared?
Yep, I think he has.
Paula, there's one more question relating to sort of particularly ESG reporting and how mandatory it is at the moment, or is likely to become, given that you were saying about the need to sort of be able to establish KPIs and that sort of thing and be able to report. Is that likely to be something that's going to be more forthcoming in the future, more mandatory reporting, that sort of thing?
Yeah, absolutely. I think, in terms of the landscape, there are a lot of voluntary standards out there, but also increasingly there are references to kind of mandating reporting for companies. Some of it is mandated by size of company, for example. I mean, the Companies Act as long ago as 2006 kind of introduced requirements for large companies. So that is more than 500 million in annual turnover and more than 500 employees. So as part of the annual reporting for large companies, non-financial information has already been part of annual reports. But in 2022, that act was expanded to include sustainability. So now those companies who qualify have to discuss their strategy, their processes, their due diligence about the environment, about social matters, about anti-bribery and corruption. So I think absolutely that agenda is going to be ramping up. We are going to see the requirements enshrined more and more in legislation. Large companies in particular and companies in particular sectors are going to have to be reporting more. So the more we can collect information, the more we can look at our supply chain and get in place those processes and procedures that better to equip ourselves when those regulations come. Rob's already talked about the Modern Slavery Act, where organisations have to report annually on the actions they take to eliminate slavery. And then, of course, there's all the Gender Equality Act reporting that certain businesses already have to do. So I think there already is a lot of reporting, and it is only going to the requirements are only going to grow. Miles, you're back.
Yes, sorry, technical problems today. Just had one more question. I was just going to add in terms of reporting. Sorry, the other thing to think about is in terms of things like bank facilities, which quite often have environmental reporting requirements now. There are now specific green facilities you can see, but even on very standard term loan facilities, often they have mandatory reporting requirements now. So that's also a good place to start. I've just got one other question, which is just about where do you start if you're not sure what to prioritize, because as we've sort of touched on, there is quite a lot here. So on that one, I would say it probably does come down to what sector you're in as to what you prioritize. So for example, if you're in construction, bribery is a particularly big risk, so that may be where you start. If you're in something like food, you may start with sort of modern slavery and supply chain risk from that perspective. It really is quite specific, but I think one of the things we've touched on throughout this is that due diligence piece in terms of your suppliers, your subcontractors, it really is about building that in, because if you've got that diligence mechanism, you can then tailor it to cover various elements of these different risks. It's not just one thing. You can cover bribery, modern slavery, equality, environmental aspects, all within a single framework. So that's how I would approach that.
And I'd agree with that, Miles. You know, I think the risks do vary to some extent by sector. They vary by territory. It's really about understanding those risks as a start, and then feeding that through into all the due diligence and, you know, all of the frameworks that you then introduce as a result.
Okay, are there any more questions before we wrap up? No, I think that's it. Okay, well, I think from all of us, we just want to say thank you for joining today. It's much appreciated. This is a bit of a moving feast of an area, so we're all adapting as we go, but it is one increasingly that we have to address in various parts of our businesses. So hopefully today's been useful. We will send around the slides to everyone afterwards, and there'll also be a short feedback questionnaire, which we'd be very grateful if you could complete. We're really keen to do more things like this. So if there's any other topics you'd like us to cover in future, put that in the survey response, and we will do our best to come back to you with more sessions soon. Okay, thank you very much, everyone.